Hello, welcome to Bearpaw Media and Education's Public Legal Education webinar series. My name is Nadine Callahoo Hansen. Bearpaw Media and Education is a department of Native Counseling Services of Alberta, and our primary goals are to make public legal education understandable, accessible, and affordable for Indigenous people. We at Bearpaw are not lawyers, although we do endeavor to make sure that this information is correct and current to the best of our abilities and is edited by lawyers. Of course, laws change with elections and societal values, so this information is designed to be general in nature and may not apply to your specific situation. It may still be necessary to consult a lawyer for legal advice to assist you. For more information, you can go to our website at bearpawlegalresources.ca or follow us on social media at Bearpaw Legal. I'd like to begin by acknowledging that the land in which we gather is Treaty 6 territory and the traditional meeting ground and home for many Indigenous people, including the Cree, Saulteaux, Blackfoot, Métis, and Nakota Sioux. Today's topic will be about self-represented litigants in criminal and youth court. So what is a self-represented litigant? A self-represented litigant is a person who represents themselves in court and doesn't retain or hire a lawyer. English law in Canada recognizes the right to self-represent in court. Over the past decade, the number of self-represented litigants in Alberta has risen significantly. Small claims or civil and family court is where most self-representation occurs. More than half the litigants in family court are self-represented, while 40% of litigants in civil claims represent themselves. A victim of crime does not have to represent themselves in court. The Crown prosecutor represents the interests of the victim and society as a whole as they prosecute criminal cases. The Crown prosecutor, also known as Crown Counsel or simply the Crown, is a government lawyer. Although the Crown prosecutor is not the victim's lawyer, they do represent the interests of the victim and society as a whole as they prosecute criminal cases. They act on behalf of all members of society. The Crown prosecution has the obligation to provide information about developments of the case to the victim or victims, according to the Victims of Crime Act and the Victims of Crime Protocol are the supporting legislation for this. In most cases, as a victim, you will not need to have your own legal representation. In cases where you do need legal representation, the Crown will obtain and pay for your lawyer. Reasons for self-representation. There are diverse reasons why a person self-represents in court, including not being able to afford the cost of hiring a lawyer. Many self-represented litigants desire the services of a lawyer, but are unable to pay for them. The rising cost of retaining a lawyer is unrealistic for many who self-represent. In 2013, being unable to afford a lawyer or continue retaining a lawyer is the most prevalent and consistent reason for self-representation. Cannot continue retaining a lawyer. These self-represented litigants began their case retaining a lawyer, but couldn't afford to continue paying for the lawyer as the case progressed and did end up finishing their case self-representing. Some don't qualify for legal aid, as well as being unable to afford a lawyer. The people in this situation are often those who are forced to self-represent as they have no other choices. They self-represent out of necessity. Limited access to lawyers. These are people who may live in remote communities with very limited access to lawyers and legal services. Out of necessity, they also self-represent. Some prefer to have control over their own case. These people are often educated and believe that they can handle their own cases. Easily accessible legal information online. And so more information on the law and legal representation are available online. And so more people are accessing information that way. And then we have those with a mistrust of the justice system, such as mistrust for lawyers, judges, the courts, etc. These are often people who have had previous negative experiences with the justice system and steer clear of retaining legal representation. So then why do Indigenous people specifically self-represent? Self-representation in court by Indigenous people results from various factors, some that are similar to non-Indigenous self-represented litigants. And these include inadequate access to lawyers, particularly in remote areas, absence of quality services created, implemented, and provided in a culturally appropriate manner by each First Nation. Inadequate access to computers, the internet, particularly in isolated communities. The cost to access the services, particularly travel costs. The need to relate to other Indigenous people providing the service. Need for Indigenous specific services created and delivered by Indigenous people. A person's poverty may fuel the attempt to find a pro bono, that's a big fancy word meaning free, pro bono lawyer, but often lawyers do not take on the cases of the poor because of the entrenched social problems and multi-issue complications they encounter in the process. In this case, lawyers often don't think they can solve these social problems through representing the person, so they choose not to represent them at all. So what are some of the challenges of self-representation? Although a right to self-representation in court exists, it also comes with its challenges. Self-representation is not as easy as it sounds. It can take a toll on you physically, mentally, and emotionally. Self-representation can be a complex and at times overwhelming experience. Navigating the complex justice system without the assistance of a lawyer can be stressful for numerous reasons, which include the huge learning curve self-representation is for most self-represented litigants, coupled with the stress most are already experiencing due to the case they are involved with. Self-representation will take a lot of your time. Most legal issues do not get resolved quickly, especially if there are any complications or a multi-issue situation exists. The justice system is set up for lawyers and judges, with many parts of the justice system full of arcane procedures, processes, and information that those who are not legally trained may have difficulty understanding or even being aware of it in the first place. Additionally, some in the legal industry, particularly some judges and lawyers, harbor less than positive attitudes towards self-represented litigants. As a self-represented litigant, even after thoroughly engaging in legal research, preparing, filing, and processing all necessary documents, attending necessary meetings, and appearing in court, it can be difficult to know what is important, what isn't, and how to anticipate the next step in the process, as well as the outcome without experience, understanding, knowledge, and legal training. So there are reasons that some feel self-representation is less desirable than being represented by legal counsel, including the following. Practically speaking, self-representation is often inefficient. In many cases, self-represented litigants do not have the experience, expertise, understanding of the justice system and its processes and procedures, and legal training to navigate their case alone. This means that processes that may normally take less time may take more time with a self-represented litigant on one side of the case. This can overburden the courts and the rest of the parties involved. Self-representation often lengthens the trial process and reduces the likelihood of reaching an agreement at the end of the process. As many self-represented litigants are unaware of or do not understand the benefit of settling their case outside of court and when and how to make decisions about settlement, the trial process can drag on unnecessarily. This again creates more burdens, including financial burden for all parties involved. Without the help of a lawyer, self-represented litigants may not be aware of the benefits of settling their case outside of court. Without experience, knowledge, understanding, and legal training, self-represented litigants may be unable to foresee the outcome of their trial or compare and contrast it with their settlement options. This means they may be less successful at settling their case, resulting in a judge deciding the case, which takes more time and again, often creates more financial burden. There is a lack of plain language legal information for self-represented litigants. Even the legal information available to them is often not written in plain language. For example, even some of the court guides designed to help the public understand the court processes and procedures require some level of understanding to make the best possible use of these resources. The lack of plain language legal information about the step-by-step process of self-representation may be a serious drawback for those wanting to self-represent. Even with some legal training, this information is often full of unexplained legal jargon that is difficult to decipher without the help of someone who is legally trained. Additionally, necessary court forms that must be submitted to provide information to the court and move your case along often contain unfamiliar legal jargon and present a barrier to success for many self-represented litigants. So now where to start? First of all, you need to figure out roughly what your legal issue is. This may sound really easy, but distilling a dispute down to one sentence requires knowing the facts and the law. If you are simply at the fuzzy stage where you feel an injustice has been done to you or the party suing you is wrong, get your facts in order. 2, marshal your facts. So gather and organize your facts. Write out in simple language in chronological order all the facts that you think are important to your case. Not all facts will be important in the end, but you can come back to the facts later. Start thinking about how you're going to prove each and every one of these facts. Through a witness, must be first-hand information. Through documents, must be originals. And through an expert, must be giving an opinion on the particulars of your case. Figure out the applicable law. Is there legislation that applies to your case? Is there case law that applies to your case? The answer to both these questions is probably yes, but how do you find it? Rather than turning the information overload that is the internet, use your local resources. Go to your courthouse library. Consult with the librarians about how to find information relevant to your issue. They can teach you how to search for legislation and case law. Look for cases where judges explain what is important in cases like yours. Go back to your facts and narrow them down. Focus on the important parts and forget the rest, even if you're emotionally attached to them. Then figure out the appropriate venue to bring your dispute. If you're suing someone, it will be up to you to decide where and how to sue them. This may mean suing in small claims or the Court of Queen's Bench in Alberta or the appropriate administrative tribunal, such as maybe the Residential Tenancy Board. Once you know the venue, you need to figure out the rules for proper procedures. You must follow these rules. These rules will be listed somewhere, so talk to that court librarian. These are just rudimentary tips to get you started with your legal action. While you might not be able to pay a lawyer to do the whole thing for you, you may be able to pay for an hour or two of a lawyer's time. It may be worth it to consult a lawyer to see if you're not missing anything and that you're doing everything correctly. Also, consider hiring a lawyer to do only a portion of the litigation, like draft pleadings, legal research, or a court appearance. As a self-represented litigant, ensure that you thoroughly explore the option of mediation as you handle your own case. If it's not offered, ensure you raise the issue. It's best to consider mediation before going to court, as many matters can be settled out of court. Saving time and potentially reducing costs. Settlement is often the best outcome. Mediation can offer a chance for both parties to come together in the presence of a third party to potentially resolve their case, helping you reach an agreement, but also saving time and potentially money. If at all possible, have someone with legal experience, such as a paralegal, someone who can give you legal advice in the community, or a lawyer who you pay for something called unbundled services to review the court forms you are required to submit and the documents that are drafted. Even better, if you can pay a lawyer for unbundled services, have them draft your documents. In doing so, there's a greater likelihood there will be fewer errors, which will take more time to correct. If the cost of a lawyer overstretches your income, consider hiring a lawyer on an unbundled basis. This means that you can hire a lawyer on a task-by-task basis, and usually does not mean you will have to pay a retainer to engage a lawyer. For example, you could hire a lawyer to draft some documents for you or to attend a hearing, but you would still be representing yourself in your own case and doing a majority of the work. Unfortunately, lawyers who offer unbundled services are often few and far between in most communities. Some resources that may be of help for a self-represented litigant. In Alberta, designated court staff, such as those in the Family Law Information Center, the Law Information Center, and court workers are very important resources for those representing themselves in court. These court staff can help provide necessary legal information for self-represented litigants. If you are representing yourself in court, it's very important to be as prepared as possible. Most self-represented litigants experience a huge learning curve during the process, and having access to and utilizing the right resources efficiently is imperative to success. This means self-represented litigants need legal information and resources. As you begin collecting legal information and doing legal research in order to handle your case, an important distinction to understand is that between legal information and legal advice. It's important to know who can give you specific types of information you're seeking. Legal information. This gives you information about your legal rights, how legal processes and procedures work, and where to go to get more information. This information is general and is not tailored to specific situations or individual cases. The process of obtaining legal information can help a person understand if their problem is a legal one, what the next steps and options are, and where to go to get further help. It's also called public legal education. Those who can give legal information are those who have current knowledge of an area of law, such as a community worker and some court staff. These people cannot give legal advice. However, legal advice differs from legal information because legal advice provides interpretations of the law. Instead of just giving information about the processes and procedures that support the law, legal advice also deals with a particular situation and applies legal rules to these specific contexts. Options are given depending on specific situations, even if they're dealing with the same legal problem. Those who can give legal advice are lawyers, licensed paralegals, and community legal workers at community legal clinics. An important reminder following the distinction between legal information and legal advice is that court clerks cannot help you fill out forms or paperwork. That would qualify as giving legal advice, and that is not their role or responsibility. Instead, go to one of the free legal self-help centers in Alberta, Flick, or Link, where you can consult with someone who will help you fill out forms and paperwork properly. The most effective legal resources are those where you can have face-to-face interaction with someone giving you legal information. These resources might include meeting with designated court staff to obtain legal information, although not legal advice, as they are prohibited from providing legal advice, such as legal self-help centers where staff can give you the legal information you need for handling your case. Even though there is an increasing amount of information about self-representation online due to rising numbers of self-represented litigants in the court, this information can never fully inform or be solely depended on. Getting good legal information from someone face-to-face is not a guarantee of success. However, it can allow a self-represented litigant to interact with another person who has some level of understanding of the court, can give them some legal information to whom they can ask questions and gain some tangible help with filling out the right forms and submitting them that an online resource cannot provide. So let's get into the trial process. A trial occurs if the accused pleads not guilty and will take place before a judge alone or a judge and jury. And the people that will be involved in that trial will be the Crown prosecutor, the defense, the self-represented litigant, and the judge, or in Court of Queen's Bench, also called the justice. Once the trial process begins, the case is called. When the clerk calls the accused's name, the accused will get up and go to the accused's table or the defense table. The judge addresses both the defense or accused if they're self-represented and the Crown. The judge will ask if both sides are ready for the trial. If yes, the accused will sit and the Crown will begin presenting their case. An exclusion order may be requested by either the Crown or defense. This means that all witnesses not presently giving testimony have to leave the courtroom and will be called in one at a time when it's their turn to provide testimony. The accused will sit in the public area when they first arrive, and then once the clerk calls their name, will get up and go to the accused's table. The Crown will present their case first. The Crown will examine, ask questions to all of the Crown witnesses. A self-represented litigant or defense will listen very carefully to everything that each witness is stating to hear if there are any inaccuracies, errors in what they're saying. After each Crown witness presents their information and the prosecutor finishes questioning each one, then the defense or the self-represented litigant will ask questions of each witness called by the prosecutor. As I'd mentioned earlier, you want to listen carefully while the witness answers the Crown's questions. Go slowly when you're asking questions. Aim to ask questions that have yes or no answers. Tell your version of the story to the witness so that they can disagree with it or agree with it. Do not ask unrelated questions. Redirect, and then the Crown will have closure of the case. And so the Crown calls each of their witnesses and questions them. After they finish questioning each witness, the defense or self-represented litigant will get to cross-examine, also question each witness. And then after the cross-examination from the defense, the prosecutor has an opportunity to redirect or ask any follow-up questions of the witnesses. Once the Crown has called all of their witnesses and the defense has cross-examined everyone and the Crown has asked any redirected questions, if there are any, then the Crown rests. And that tells the judge that they have finished calling all of the Crown witnesses. Then the defense presents their case. Through defense or self-represented litigants always have the choice whether they want to testify themselves or not. You are not required to testify. If you do decide to testify, you will swear an oath that what you say is the truth. You'll stand in the witness box and share what happened with the court. You are the first defense witness if you decide to testify. And then the defense has the opportunities to start calling and questioning their witnesses. But keep in mind that after you're finished questioning your witnesses, the Crown also has an opportunity to cross-examine each of the defense witnesses, and then the defense or self-represented litigant can redirect or re-question all of the witnesses as well. Once all of the defense witnesses are called, questioned, cross-examined, and then redirected, then the defense also closes. So what are some pros or positives to having the self-represented litigant testify? It's your opportunity to share your side of the story with the judge. You may be the only witness to what you're being charged with, and so you may not have a choice but to testify. You'll have a unique perspective and might have seen something that no one else did. You may have facts about the offense that no one else does. Can help show that you did not commit the offense. But keep in mind that it is not up to the defense to prove that they're innocent. It's up to the Crown prosecutor to prove beyond a shadow of a doubt that the alleged offender is guilty. Because after all, we are all innocent until proven guilty. You may choose to testify because what you say may differ hugely, in fact, sometimes from what the Crown's witnesses are saying. The judge gets to decide whether you are a truthful person or not. And so it also gives you the opportunity to show your character as a truthful person. However, there are also some cons or negatives to testifying. If a self-represented litigant chooses to testify, they open themselves up to be cross-examined by the Crown prosecutor. The Crown will pinpoint weaknesses in your story, evidence, and case. If you have a criminal record, the Crown can discuss this in court if you choose to testify. But if you don't give evidence as a witness, they cannot discuss your record in court. The Crown may ask you questions about things you don't want to talk about. You don't have to give evidence. If the case against you, the accused, is not strong, then it may not be necessary for you to testify at all. Remember, the Crown has the burden of proof. Before trial, talk to your witnesses about cross-examination. Let them know what will happen, by whom, and what to expect. After all, if you were to hire a lawyer, they would do witness preparation as well. Always allow witnesses to tell their own version of events in their own words. Don't ask leading questions or questions that hint at the answer you want. Crown prosecutor will cross-examine if they so choose. During cross-examination by the Crown, the witnesses can be asked if they have a criminal record. Also remember to tell your witnesses about the exclusion order. That means that they can be asked to leave the courtroom and sit outside the courtroom waiting for them to be called in one at a time. You can also ask your witnesses more questions following the Crown asking them questions, remember, called the redirect. When you have no more witnesses to call to give evidence, tell the judge. The defense rests. If you decide you're going to call witnesses and you think you might need to subpoena them, a witness must have seen or heard something. It can't be third party. It has to be firsthand seen or heard. They cannot simply share hearsay of what someone else told them. The beliefs and opinions of witnesses are not of interest to the courts. If there is any doubt at all that a witness will show up to give evidence in court, you should get a subpoena. To obtain this order, go to the provincial court at least 2 weeks before the trial. Fill out a subpoena for each witness requiring one and get it signed by the court clerk. Once the clerk has signed it, you will need to serve the subpoena on each witness you have one for. Take a copy and physically give it to the witness. Once served, you must go back to the court clerk and fill out something called an affidavit of service for each subpoena and file it with the court clerk. The affidavit of service is you swearing that you did in fact in person serve the subpoena to the witness on what date and time and location. Then we have once the Crown and the defense have rested their cases, so they've called all their witnesses, everyone's cross-examined and redressed and everything, then everybody, each side gets an opportunity to provide a submission. This happens after the Crown and defense finish their case. It's a time for both parties to say some final things to the judge, some lasting impressions or words. It's a time to sum up all the things that are favorable to your case. You want to keep it brief. At this point, no new evidence can be presented. Once both the Crown prosecutor and the defense have rested, it's telling the judge that they have presented all of their evidence. And once they've rested, no new evidence can be entered. The submission is also an opportunity to talk about the weaknesses of the Crown's case. Remind the judge of a couple of strong points. Share with the judge the reasons why your witnesses should be believed. The Crown prosecutor will also be doing this, but will be trying to prove that the accused is guilty beyond a reasonable doubt. Remember that it is the Crown's responsibility to provide proof beyond a reasonable doubt of guilt. And then we have the decision. This happens after submissions have been given. The judge's responsibility is to weigh all the evidence they have been given from both sides and make a decision. The decision is either not guilty and you're free to go and there will be no criminal record, you've been acquitted, or guilty, you're convicted and sentencing will follow. Before you're sentenced, you are allowed to speak. This is called speaking to sentence, where you share everything and anything with the judge that may allow them to give you a reduced sentence. You can also ask for an adjournment at this time to have sentencing happen at a later time. The judge does not have to give you an adjournment and will only do so if you can give them good reason for it. Be ready to speak to sentence on the day of trial. You cannot argue with the judge over the decision. However, you can appeal the decision within 30 days of the trial. So when you're preparing to speak to sentencing, you speak to sentence when you either enter a guilty plea or are found guilty of a crime. Speaking to sentence is your opportunity to tell the judge something about yourself so that they may give you a lighter sentence. Remember, good impressions can go a long way. Keep this information in mind as you go to court to speak to sentence. Always be in court on time. Dress neatly. Ensure your appearance is suitable. Speak clearly. Always stand when speaking to the judge and when the judge is speaking to you. Show respect and courtesy to judge at all times. Address them as your honor, sir, or ma'am. Be quiet while court is in session and bow to the judge when entering or leaving court, even if they don't see you. The goals when speaking to sentence. Tell the judge what sort of person you are, your age and background, your education, family circumstances and history, employment, previous criminal record, and any other things that you feel would contribute to the judge getting a positive overall understanding of who you are and your circumstances. Tell about the circumstances of the offense. What was happening that led up to the offense? It's always important to tell the judge about any time you've spent in remand so that you may get credit for it. Following speaking to sentence, the judge will pass sentence for the crime. Stand when being sentenced. And so that concludes our presentation on self-represented litigants. Thanks for watching.